what is going to happen when the petitioner dies and the petition remains pending with USCIS or NVC. What are we going to do with that petition? Is the beneficiary still able to claim an immigration benefit after the petitioner dies? In this video, we are going to talk about the in and out of this subject, and we're really going to just lay out the foundation for you so that you can be able to claim your benefit, right? Even after the petitioner dies. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex US immigration laws. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and share, like, and don't forget to comment below. Also, please don't forget to join us on our private Facebook group where we answer questions live at least twice a month. If you need a consultation with me, please go ahead and click the link in the description box, okay? So you can schedule your consultation on your own time. Let's get right into the subject, the death of petitioner or principal beneficiary. Who's qualified to claim the immigration benefit, right? We are talking about the applicant, okay? In the United States, when the qualifying relative died, the applicant continued to reside in the United States on the date of the decision on the pending application, and the applicant is at least one of the following, okay? A beneficiary of a pending or approved immediate relative immigrant visa petition, a beneficiary of a pending or approved family-based immigrant visa petition. You see what I'm saying? Pending or approved, okay? Any derivative beneficiary of a pending or approved employment-based immigrant visa petition, the beneficiary of a pending or approved refugee asylee relative petition, I-730, a person admitted as a derivative T or U immigrant or a derivative asylee. So, and then the list goes on too with basically we're talking about VAWA self-petitioners as well. All of those people, right, might be able to benefit from the immigrant petition even after the petitioner dies, okay? What are the requirements? Now let's talk about the requirements. Residency requirement, that's number one. Number one is residency requirement, okay? The applicant must have resided in the United States when the qualifying relative died and continues to reside in the United States to adjust status based on the deceased qualifying relative. We have the number one big thing is residence, okay? When they talk about residence here, they're talking about in terms of by the time the petition dies, they're going with the death of the petitioner, okay? By the time the petitioner dies, you were living in the US and you continue to live in the US. If you had traveled abroad temporarily, again with the intent to come back, you still qualify. You still meet that residency requirement. That's the major one, okay? Then we have, once you met the residency requirement, then we have that the second requirement is that the underlying petition is approved before the death of the qualifying relative. The underlying petition is approved under INA 204I. The pre-death approval of the underlying petition is reinstated, or the non-citizen was admitted as a derivative T non-immigrant, or as a derivative asylee under INA 208B3, and you meet all other requirements of adjustment of status. We are going to focus on two things here, right? The petitioner dies. Petitioner is approved, the petitioner dies. Remember, in order to adjust status, you have to be eligible to adjust status. In other words, you have to meet adjustment of status eligibility requirements, which includes sponsorship as well. So we're going to focus on two subjects, as I said, sponsorship and waivers. Let's say that you were supposed to get a waiver from the petitioner, right? Because you do not meet one of those admissibility requirements. So pretty much you are inadmissible, let's say based on fraud, misrepresentation, you name it, those inadmissibility issues. And you were going to use the petitioner as a qualifying relative for the purpose of applying for a waiver. So now the question becomes, can I still apply for a waiver with no qualifying relative? The answer is yes. They're still going to treat it as if the person was still there, right? So you are still going to apply for the waiver under those circumstances and claim extreme hardship based on the person that died, okay? So that's how it's going to play out. You're still going to, the same qualifications or the same statutory requirement for waiver is still going to be applicable under your circumstances. They're not just going to waive that requirement because the petitioner died. No, you're still going to have to demonstrate extreme hardship and apply for a waiver and hope that the waiver get granted so that you can adjust status. Whatever eligibility issue you have, inadmissibility issue you have, it still has to be waived through the waiver process. It's not going to go away. That's what I want to say. That's the one subject I wanted to address. The second subject is about sponsorship requirement. I-864. You have to be able to get a substitute sponsor even though the petitioner had already, let's say, send the application to either USCIS or NVC. You still have to get a substitute sponsor, because now the sponsor that was supposed to sponsor you is no longer available by way of passing out. You have to get a new sponsor. So they're not going to waive those requirements just because the petitioner died. You know, so those are the two things I wanted you to really focus on: sponsorship and waivers. If you were required to file for a waiver, you're still gonna go ahead and file it. If when it comes to sponsorship, you still have to get a substitute sponsor, but with waiver, at least they know that the qualifying relative that you wanted to waive your inadmissibility issue had passed away. They understand that, but the waiver still has to go through and demonstrate extreme hardship. And I think at that point, even the waiver become really easier to demonstrate extreme hardship because the person in question is no longer available, you know. So that's all for today. I wanted to really talk about what is going to happen when somebody dies, the petitioner or the principal beneficiary. Are you still eligible? Can you still claim your immigration benefit? The answer is yes. You can still claim it, provided that you are among those people that we just cited in this video. Okay? If you need a consultation, again, please click the link in the description box. Schedule your own consultation. You can call if you want 202-751-2180. It's still the same process. I'm still going to send you the link for the consultation. Consultation fees apply. Until next time, bye-bye.